Good morning, ladies and gentlemen, dear colleagues, dear friends. When you see and hear me speaking to you today, that means on the 30th of January 2013, I do very much regret that I cannot be here in person, but I had to leave this morning early to do some other business, real business in Mumbai, and had to fly early, but I have been invited by Dr. Agarwal, the organizer of this conference, the main organizer, to say a few words of goodbye to you, maybe also to try somehow to summarize what we have learned here and what we are planning for the future and possibly for next year. And I am pleased, though I'm speaking to you today, when I address you by this video, I have actually taken it was taken a day before, namely on the 29th. I would like to talk about the following. First of all, my deepest thanks to Dr. Agarwal and his colleagues. The fact is, and I have heard this from many participants from the international scene, both from my own country, Germany, where high-ranking persons from the leading German intellectual property world, I would say, have participated here, but also from other Europeans and beyond, from United States, from dear friends of mine from all over the world whom I have met, that actually this conference, Global IP Convention, where I had the pleasure to participate for the second time this year, is becoming something for the patent world what INTA has become over the years for the trademark and also to some extent other IP world. But I think there is no other opportunity in the world at the moment where so many professionals, both in technology transfer, in the, let's say, area of obtaining intellectual property rights, notably patents, but also how to use them commercially, be it by litigation as a first contact to a potential licensee, be it by licensing, come together. What I have liked a lot here, and I have participated in many lectures, was that the emphasis was not only on the importance of getting high quality patents into place, making them enforceable in order to make them respected and in order to have a valid currency in the hands of the patent owners to commercialize technology by transfer of rights how to use these patents. But that also a lot of balancing speeches has taken place, if I may say so, namely by competition specialists who have again and again made it clear how important it is that patents are not only available at high quality, but can also be used in a fair business, whether for licensing, whether as a currency for cross-licensing. So in other words, that the rules of the game are determined by strong and reliable competition law provisions. As India is putting them into place since a couple of years, I have learned since 3 years, as China has introduced them and is at least trying to implement them, and as they are in place in countries like United States, but also in Europe since decades already. And I'm personally convinced that without the smoothening role of competition law, making it sure that no abuse of patents and other intellectual property rights takes place in the sense of blocking access to technologies, be it in telecommunication, ICT, be it in pharmaceuticals, is one of the major tasks we all face here today. It has also been interesting for me when I was invited by Dr. Agarwal to participate in a small round of experts who met here last week, actually, over the weekend actually, in a smaller group, in order to summarize these ideas, to analyze the present situation of intellectual property rights and notably patents in the world, that there was unanimous opinion of all these experts from not only India, but also Europe, also United States, even Australia, that we need, first of all, high quality patents. High quality patents, of course, mean that there will possibly not be so many patents or unexamined patent applications anymore in the world as they exist today. It also means that there are less obstacles to free competition, of course, because a patent is, as a privilege, granted to the creator and owner of intellectual property. In principle, of course, something which is an obstacle to competition, but a well-justified one on the other hand, because without such obstacles, that kind of monopolies given for a certain period of time, investment would not flow, as I'm fully convinced, into R&D, leading to patentable innovations. It would flow into real estate, it would flow into other businesses, it would flow where money expects to earn more money. And this is why we need a strong patent system. But we need also, in spite of that, make sure that access to technologies, which means, for example, in the highly standardized telecommunication world, access to certain phone standards for newcomers, so that the world is not monopolized by a very few companies. That furthermore, in the pharma world, it means that pharmaceuticals are first created because of the investment incentivized by the patent system, but also then are made available at locally affordable prices all over the world, are both major goals but also achievements of the patent system. And I'm convinced that, and all the speakers I found here, most of them at least, though some of them for good reasons have been critical towards a role which patents also can play, that out of this conference there should be kind of a proposal, if not a resolution, brought forward, as I would like to suggest, by Dr. Agarwal as the speaker of this expert group and this series of conferences, global IP conventions, which hopefully will continue 2014, brings this proposal to the attention of relevant authorities here in India and beyond. And in India, I'm specifically thinking of not only the Intellectual Property Office, but also the ministries on a federal basis responsible for these matters, like Ministry of Economics, Ministry of Justice, federations like Confederation of Indian Industry, like the Federation of Indian Chambers of Commerce, a resolution which claims for one thing a better possibility to train in large numbers patent experts. This is a need for two reasons. First, industry in India, besides of the excellent lawyers which are in a large number available in the IP field in India, needs technically trained people with an additional legal education sufficient to draft high-quality patent applications, and internationally as well as in India to prosecute them. These experts are not available in the sufficient number. I hear this from my clients in India and abroad with subsidiaries in India all the time. So there should be some kind of a training center which trains patent experts. And we are talking about numbers. We are talking about the fact that according to a country which I know very well in its development of its intellectual property system, namely China, where I have had the pleasure to help even in the coming into existence of the Chinese patent law since 1981, before it even existed, 4 years earlier, where there is an annual output of 2,000 to 4,000 patent experts or patent attorneys. 10 years is 40,000. That India must and should do something here. I think India needs, in the expectation of more and more innovations being made across all industries here in India and in universities, needs patent experts in a large number. Maybe you need per year an output of at least 1,000. But what you also need is, on the other side, that the patent office is supported in its effort in kind of an examiners academy to train much more qualified examiners that at the moment are there. Because as soon as the Intellectual Property Office has enough examiners available, these examiners can get rid of the backlog of unexamined patent applications 80% of whom are owned by foreign companies, which are now as uncertain and undefined obstacles against competition in the field like stones which you cannot get out of the way for Indian industry. So Indian Patent Office, with more patent examiners, maybe another 500 to be added or 200 to be added over the next 5 years per year, will then be able to get rid of these from foreign countries imported patent applications into India, to let only the valuable ones survive in the form of high quality patents. But also this abundance of new examiners can quickly examine and search domestic applications by Indian companies and universities in order, before the 1-year expiration of the Paris Convention, the applicant has some reliable basis in the form of a first office action of the Indian Patent Office as to whether the invention is probably patentable and worth to be subject of further investment into foreign filings, particularly for PCT. This is exactly how Germany, if I may conclude with this, proceeds, where there is a standing instruction of the President of the German Patent and Trademark Office, which means that within 8 to 10 months after filing a patent application at the GPTO, without claiming priority, you have your first examination, your first office action. And that means before you have, after 12 months, to invest into PCT or into Paris Convention supported foreign filings, you know as the applicant, using the German patent application as a reliable and not costly source of information, as a test application, so to say, whether it is worth to go abroad or not. So my sincere wish is that out of our conference here, which has been so beautiful, under the leadership of the main organizer, Dr. Agarwal, such kind of a resolution will be formulated and will be sent to the authorities in India that have the power, have the budget, have the influence to create such a training system we have talked about, which hopefully will be able to play a dual role, namely to train technical experts both for the patent office and for the patent expert drafting profession, because in both fields, in both areas, the qualification you need is about the same. And maybe one comes somewhere in future to a system which would be the ideal world, that people, after having passed such an examination in such a training center, go first to the patent office or to industry, work there for a few years, then change sides and go to the other side. Examiners will become patent experts or patent attorneys will become examiners, and that would be for the benefit and the better and mutual understanding of both of these systems. I would like to conclude by thanking the organizers, particularly Dr. Agarwal, sitting next to me here, my dear friend, once again for the wonderful days I could spend here, my colleagues could spend here, and I think we are on an excellent way, and cordial thanks. Thank you very much, and goodbye to everybody, and hope to see you all again. Thank you.
Thank you, Professor Heinz. We will continue to get your blessings and guidance, and with this, GIPC can become a catalyst for building capacity in the field of IP for India and for all developing nations and for the world at large, for the IP community and for the welfare of the society. Thank you very much.
Thank you. Okay, so I think that's the best we could do. Yeah.
Yeah.
So thank you so much. Good idea. Good idea.